Welcome to the EDPS Talks, an exclusive series produced by the European Data Protection Supervisor as part of its initiatives to celebrate its 20th anniversary, 20 years of protecting personal data. The talks aim to gather leading voices from all around the world to share their unique perspectives on privacy and data protection. In today's talk, it is really an honor to discuss these topics with our guest, Koen Lenaerts. Our guest really needs no introduction to anyone vaguely familiar with union law. Mr. Lenaerts is President of the Court of Justice since 2015, and before that, he has been Professor of European Law at the Katholieke Universiteit Leuven since 1983. Thank you, Mr. President, for having us at the premises of the European Court of Justice, and welcome to the 20 Talks. I would like to start this interview with a question that aims at the essence of your role as President of the Court of Justice, which is also a question that we ask to all the interviewees. What does privacy mean to you? What does data protection mean to you?
Well, both privacy and protection of personal data are of utmost importance in our modern liberal society. This is clearly, and for good reason, endorsed by the fact that they are fundamental rights guaranteed by the Charter of Fundamental Rights of the European Union. As regards privacy, Article 7 of the Charter states that, I quote, "Everyone has the right to respect for his or her private and family life, home and communications." According to Article 8 of the Charter, I quote again, "Everyone has the right to the protection of personal data concerning him or her." These rights, which are closely connected, are of course also protected under the European Convention for the Protection of Human Rights and Fundamental Freedoms, the so-called ECHR, as well as under the laws of the member states. In 1969, 40 years before the Charter entered into force, the Court of Justice recognized in its Stauder against Ulm judgment that fundamental rights are a source of community law. Coincidentally, this was a case which concerned both privacy and data protection. There was, however, no need for the court to go into more detail on this issue to resolve the case. Neither of these fundamental rights are absolute rights, but must be considered in relation to their function in society. They may therefore be subject to limitations. Their essence, however, must always be respected. In particular, the fight against international terrorism in order to maintain international peace and security may justify such limitations, but they must always be proportionate and may not lead to an atmosphere of constant surveillance, as described by George Orwell in 1984. That is why the Court of Justice declared the Data Retention Directive invalid. Another important area in which privacy and data protection come into play is, of course, social media, where these fundamental rights are to be protected against big tech.
Thank you, Mr. President. Thank you for already in your first answer going from the origin of the judicial protection of personal data to today's topics. And indeed, in our society, data is really everywhere. And the rules that the European Union adopts to govern innovation based on such data are sometimes perceived as a hurdle to innovation through technological development, or as an obstacle to law enforcement tasks. As a guarantor of the rule of law, as President of the Court of Justice, what are your perceptions on this?
As you just said, the Court of Justice is the guarantor of the rule of law at EU level. Being a court of law, the court does not take any initiative in regulating the processing of data. It is not for the court to make political choices and thus to give preference on the basis of specific political, societal, or economic interests, or a specific vision to a more generous or to a rather restrictive approach as regards data protection. When it is validly seized of proceedings which relate to EU legislation on the processing of data, or to the fundamental rights to privacy and to protection of personal data, the Court of Justice, of course, has to fulfill its judicial tasks and thus to examine the case at issue and find a solution by applying the law. In doing that, the court has to take into account all of the legal aspects involved. Notably, other fundamental rights may come into play, such as the right to liberty and security, Article 6 of the Charter, the freedom of expression and information, Article 11 of the Charter, the freedom to conduct a business, Article 16 of the Charter, the right to property, Article 17 of the Charter, and the rights of the child, Article 24 of the Charter. Of course, the general interest in public and national security also comes into play. The Court of Justice, which itself very much benefits from technological innovations in its daily work, is not at all indifferent to economic development through technology or to law enforcement tasks. It simply has to ensure that those aims are being pursued in full respect of the law and that all rights involved are properly balanced.
Thank you, Mr. President. Indeed, the case law in the field of both privacy and data protection has grown significantly, allowing the attentive reader to find important teachings of constitutional value. However, some rulings of the court in this field can be said to be rather prescriptive in comparison with legislation that remains broadly worded or perhaps even flexible. To what extent is this approach imputable to the Union or national legislator not being precise enough in regulating interferences with fundamental rights? Or is this more a question of the court really defending the effectiveness of the Charter?
Well, as regards the issue of data retention, after declaring the EU Data Retention Directive invalid, the Court has repeatedly received questions from courts of the Member States regarding the conditions under which communication traffic data may be stored and otherwise processed under national law in order to safeguard national and public security and in particular to combat serious crime and terrorism. As the very detailed Data Retention Directive is no longer valid, the questions referred logically concern the relevant EU legislation which remains, i.e. mainly the e-privacy directive. That directive provides, as a basic rule, that the Member States have to ensure the confidentiality of electronic communications and the related traffic data. Article 15 of that directive exceptionally allows the retention of data for a limited period in order to safeguard national security, defense, public security, and to combat crime. It is on the basis of this provision, read in the light of the Charter, that the court had to answer rather detailed questions. In order to facilitate the work of the national judges, the judgments by which the court answered those questions are drafted in a didactic way, pointing out which measures are admissible and for which purposes. As to data protection beyond electronic communications, the General Data Protection Regulation, the famous GDPR, provides for a rather detailed legal framework for the processing of personal data. Nevertheless, questions on the GDPR have in recent years led to numerous requests for a preliminary ruling by the Court of Justice, both on substantive and on procedural issues.
Thank you. Indeed, the case law of the court immensely help enforcer, such as the EDPS. Nevertheless, there is still a long way to achieve satisfactory enforcement of the Union data protection law. The challenge can only grow now with the advent of AI. Mr. President, may I ask you what have emerged, in your view, as the critical, the central aspect in the recent jurisprudence that might also help for the future?
In its judgment, Ligue des Droits Humains of the 21st of June 2022, a fundamental Grand Chamber judgment on the Passenger Name Record Directive, the Court of Justice explicitly dealt with the use of artificial intelligence in the processing of PNR data against predetermined criteria for the purpose of identifying persons who may be involved in a terrorist offense or serious crime. The court held that the requirement that the criteria must be predetermined precludes the use of artificial intelligence technology in self-learning systems, the so-called machine learning, capable of modifying without human intervention or review the assessment process and in particular the assessment criteria on which the result of the application of that process is based, as well as the weighting of those criteria. The court observed that, I quote, "Given the opacity which characterizes the way in which artificial intelligence technology works, it might be impossible to understand the reason why a given program arrived at a positive match." End of quote. Another interesting judgment in this context is the SHUFA judgment on scoring, that is the automated establishment of a probability value concerning the ability of a person to meet payment commitments in the future. The Court of Justice held that the establishment of such a score must be regarded as an automated individual decision, prohibited in principle by the GDPR, insofar as the clients of the company providing it, notably banks, attribute to it a determining role in the granting of credits. Indeed, in such a case, the score itself affects the person concerned significantly. It is difficult to predict what this finding, in its specific context, might trigger in future case law, and as a judge, I am not meant to do so. Suffice it to say that this finding stresses the importance of human control of measures that may lead to severe interferences with fundamental rights. With respect to the specific task of judges, artificial intelligence may only support human intelligence, but may never replace it. At a court of justice, artificial intelligence is already used as a support tool for translation and for research. Its use is also explored to enhance access to justice and transparency, for example by means of automatic subtitles for hearings that are streamed.
Thank you, Mr. President, for stressing indeed the human-centric nature of the work, also of the enforcement of European Union law, especially European Union law in the field of fundamental rights. May I ask you, and this will be my last question, which is a more general question that we always also ask to all interviewees for this series of 20 talks. May I ask you if you think about the next 20 years? The EDPS now is turning 20, so we ask our interviewee, what about the next 20 years? How do you envisage society and data protection in consolidated, in mature democracies? Where should we invest more to create indeed a more human-centric, a human-controlled digital future?
Well, politicians are without doubt much better placed than I am to answer these questions. Being a judge, I limit myself to saying that access to justice and the effective protection of fundamental rights, in particular the fundamental rights to privacy and to protection of personal data, must be guaranteed at all times. Just as the law serves the people, digital technologies must serve the people. Democratic restraints must be in place. I add that for our liberal democracies, open and constant political debate is of utmost importance. Digital technologies can be of great help in facilitating this debate, particularly in a union with 24 official languages. But it goes without saying that the risks connected with those technologies, such as fake news, must be addressed and must be contained.
We're almost at the end of our interview, Mr. President. It was a real honor having you today. And thank you for shedding light on these very delicate aspects. Thanks also to our listeners for this special episode of the EDPS 20 Talk series, celebrating the 20th anniversary of the EDPS, the European Data Protection Supervisor. My name is Daniele Nardi, and today's guest was the President of the Court of Justice of the European Union, Mr. Koen Lenaerts. Thank you very much again.
Thank you.